Good morning, everyone, and welcome to MorePay's webinar, which is the first in our three-part ERA Readiness Series. Today, we'll be covering getting to grips with Day One rights. I'm Hannah Booth, the Content and Communications Manager here at MorePay. So before we get started this morning, I will run through a couple of pieces of housekeeping. So looking at the agenda for this morning, my colleague Patrick will begin by discussing why Day One rights matter and why risk has increased. He'll then move on to look at SSP changes, including the removal of the lower earnings limit and waiting days. Patrick will also run through parental leave and the early stage risk, and he'll then move on to discuss paternity leave and the operational complexity. And finally, Patrick will look at the practical steps and best practice that you can take to prepare for the implementation. And as usual, we will finish with a live Q&A at the end of the main presentation. So in relation to the Q&A, you will see that your microphones are on mute, but we do want to hear from you. So please drop the questions into the question panel as shown here. We have had an incredible response to this webinar. So we will have lots of questions, I imagine, but we will do our best to get through as many as possible. And we will, as usual, send a recording and a copy of the presentation out via email this afternoon. Now, hopefully you can all see the slides clearly, but if you would like to make them bigger on your screen, you can simply click on the three dots in the top right-hand corner of the GoToWebinar panel and then toggle to full screen, and this will make it slightly bigger for you if that helps. So before I introduce Patrick, I'm conscious that we will have some people on the webinar this morning that aren't familiar with MorePay, so I will give a very brief introduction. We provide payroll and HR software as well as outsourcing services to UK businesses. We've been around since 1966 and have all the accreditations you'd expect. And our promise is to make payroll and HR easy. And here's how we do it. We provide easy software, quality services, and worry-free compliance. And on this slide, you can see some of the businesses who trust us to take care of their payroll and HR. And we're also award-winning. On this slide, you can see some of the industry awards and shortlists that we've picked up over the past couple of years. Now, if you would like to find out more about us, drop me a message in the Q&A panel and I can arrange for one of my colleagues to make contact with you. So that's enough about us. I will now introduce you to Patrick. If you've joined some of our webinars previously, then I'm sure you will be familiar with Patrick. Patrick's our head of HR operations, and he has over 15 years of HR generalist and operational business unit management experience. Patrick leads our operational HR services teams and is focused on providing the best possible advice and service for all our customers. So I'll now hand you over to Patrick to get started on today's session. Thank you, Patrick.
Thank you, Hannah, and thank you for everyone today. Good morning, and if you're watching this in a recording, I'll enjoy when you're watching it. But today, thank you again for spending an hour with us today. Calendars are tight, so I appreciate everyone is fitting this in. And Day One rights, you know, they can sound like one of those phrases that belongs in a handbook rather than the real world. But the whole point of today is making it practical. So we'll look at what changes, where it bites first, typically on day one, and what you can do to reduce the risk, cost, and most importantly, probably the hassle of potential risks that fall from these things. So just to set some expectations, this isn't a session, as you probably, if you've joined me some of my previous webinars, where I try not to read as much legislation at you. I think this session is more about the moments that actually happen, you know, the practicalities in terms of, you know, from SSP and that manager ringing in, asking you for help about that employee, all the way through to, you know, assumptions around payroll and how that things trickle down, and incorrect pay can be now a huge risk to the business from April. So from April 2026, Day One rights, they're being added to. They stop becoming a technical phrase in the HR sphere. They become a real operational risk area for employers, and that includes not just the ones that have been introduced. Today we're actually going to, you know, actually look at what it currently exists as well. And I thought that'd be a sort of handy tool to sort of, and a moment to reflect about what are Day One rights what exist, coupled with the additional ones. And what are we looking at when an employee starts? So to put simply, day one right is a statutory employment right that applies from the first day of employment. No qualifying service, no waiting periods, no grace period to bed in the process. For HR people, HR and people teams, that changes the stakes, decisions made in week one onboarding, payroll setup, manager conversations, policy applications can trigger immediate legal exposure if things go wrong. So this session is going to focus on what's actually changing, where organizations and your businesses are most likely to trip up, and what good looks like in real world practice. Again, not just academia, this is actually the real world and how we're actually going to manage those risks. As I mentioned, we're going to cover those day one existing rights and look at the bigger picture when employees on board, new employees, employers, sorry, on board new employees. This isn't, again, I'll probably just clarify, isn't about policy perfection. It isn't about, this happens from, it's about day one. What does it look like when those service thresholds are removed, and how big that legal exposure is to yourself? So we'll look at that. We'll look at some really good examples about how to sort of mitigate those risks. I think probably start off before we get into the reality of it, is just probably for you to have that clarity in mind is, most of us can remember what it was like in our first week of our new job. We're trying to make a good impression. You don't want to be seen as difficult. You're learning new systems, names, where the kettle is. If you're hybrid, if you're fully remote, very different, as long as you know where your own kettle is. At the same time, you're signing contracts, you're relying on what you're told. You're being signposted to a lot of information. And that's why day one rights matter, don't they? We know that as people professionals, but employees, what they know is always going to be limited based off the information that is provided to them. They're not HR policy experts. So getting that information across them clearly about what is available to them is incredibly important. And people are probably the most vulnerable. We remember that as employees. When you first start your job, you're most vulnerable when you first start. You're starting a new job. So putting that as we do, where many people in HR are empaths to a point, we focus on how that individual feels as well as what the business needs. So it's always good to sort of reflect upon, what period of time we're talking about in that employee's journey. So why day one, right? Why day one rights matter, and why is this risk escalated? So if you like analogies, I'm going to give a car one, which I'm not a very particular good driver, but I seem to give a lot of these. It's probably the shift now from these day one rights, and what the government is proposing with the ERA is speed camera is not just down your main street anymore, it's on your driveway. As soon as you begin, this is it. The behavior doesn't really change, but the timing of that enforcement does. And this is probably the key part of any day one right we're going to cover in that bigger picture. The practicalities of what's already out there in terms of the rights existing anyway, in terms of paternal, we're going to talk about parental leave, paternity leave, SSP, those things, those things are existing rights already. It's just so the behavior is not changing to a point. It's just when that timing does, and how those controls can affect you is really significant. So moving upstream, so the couple of things we want to look at now, where we are. So big parts of probably we're looking at is I suppose what is affecting a lot of these day one rights is probably that overarching creation of the Fair Work Agency. In 2026, we've discussed this last time in a couple of webinars, fundamental change in how the Employment Rights Acts are sort of enforced. Historically, this has relied on individual employees bringing tribunal cases, short time limits, employees having the confidence and time and money to pursue a claim. From 2026, Fair Work Agency can inspect workplaces, demand records, issue notices of underpayments, and impose civil penalties of up to 200% per underpayment, with retrospective recovery of up to 6 years for statutory payments such as SSP, which is 6 years for that, and 2 years for holiday or leave entitlements. So there's a big spread of enforcement there. I mean, the key sort of understanding about this is when the risk now starts, it's an offer stage for these day one rights. So not 6 months, not 1 year, removing service thresholds fundamentally changing the risks timing. So this means onboarding materials, offer letters, payroll setup, and manager guidance. These are sort of now the sort of risks that will emerge from any day one right that exists anyway, but particular ones that are coming in April. So managers in particular must all work from day one, and not when someone's passed probation and those sorts of triggers. So moving on to the next slide, please. And we just cover that and move on to the next slide. Get me on firing away today. We're going to look at a couple of the little pieces here about payroll and policy errors. So we can use probably SSP as probably a really good example about this. While not a day one right per se in the typical sense, some of your family friendly rights, it is from day one. So it is obviously a new right from the start of an employee's life cycle with you. Under the new regime, SSP underpayments, as I mentioned, can be reclaimed 6 years and the penalties can be added on top. And the enforcement relies no on, as I mentioned, the employee bringing a dispute. With the FWA looking at how this is interacting with how you work as an employer, this matters because what we're seeing at the moment is the HMRC and the enforcement data consistently shows that payroll errors happen a lot more common than employers probably realise. It could be a couple of pounds here. It could be you didn't actually correct my leave that month. You may have not started my maternity at the right time. Particular on holiday pay for variable hours, irregular hours workers, compressed hours. Those sorts of things, especially when it affects lower paid workers, are really now becoming such a significant issue on the minds of many employers. A £100 error in 1 week doesn't stay now a £100 error once penalties have been added and back pay. So there is a lot of significance in terms of sort of the payroll aspect and policy errors that by not having your day one rights attached to sort of your processes can be really significant. And I think if we move on to the next slide, I think one of the key indicators here about we're seeing with probably one of the risks of day one rights is probably managers are multiplying that risk at the moment. And I think when we look at managers depends on the size of your business, but typically, a business of 300, 400 employees, you can have a large set of managers who are expected to undertake a lot of significant roles of that employee's life cycle and decision. Particularly what we've seen with the tribunal and ACAS, there's been a lot of data showing that rising claims and volumes, across wage disputes, unfair dismissal, and discrimination, with claims increasingly linked to early stage decisions. So we know, we'll get onto this, discrimination will fall under that day one right, but it's, what we found is that the more that we find the informal handling of matters really can impact the significance later down the line in the case. Because probably, as we found, we feel that probably there's a larger protection of rights at the moment for employers, under probation to 2 years. I think we're all quite aware that many cases which when they get to, tribunal, if the employee is under 2 years, which we have seen a significant increase over the last 2 years in particular, while they may not be eligible to claim unfair dismissal, the discrimination or other day one rights have been applied as part of heads of claims in order to seek financial or recompensation for that employee. So those other rights are being squeezed in I suppose in replace of the employee not being able to obviously claim unfair dismissal. We know that's obviously going to be changing very, very soon, but it's an important reminder about, again, day one rights as a whole, about why managers apply that risk. And HR is not going to be able to govern every single manager or employee's decision. So in terms of sort of practice, where do these sort of failures come from? I suppose it's we can probably see let's wait and see responses in terms of absences and the build up of that sort of the camel that broke the straw that breaks the camel's back. Those decisions where probably spotted absences, maybe late, maybe persistent lateness, and those build up a sort of, I suppose, issues that may be surrounding an employee's journey that are not tackled at the time. And one day there's a big project and the manager obviously needs that employee in. And then they decide to walk to HR, the people team store, and say, well, I want this person gone. And probably the first question is, well, how long have they been, how many absences have they had? Is there any issues? And the probably is then an itinerary list that's provided to you to then deal with. And it's all, then it becomes very much what we find now is rush dismissals. And that is a big area of tribunals looking at, I suppose, was the right decision reached? Potentially, but was it rushed? And again, you can obviously fail. The process sort of falls down when the process is rushed. I mean, then there's again inconsistency of application of policies. Well, that can apply around, I suppose, any of your day one right policies if they're not up to date. We always find that probably, most people when they come to review the handbook as a business, it's never going to be always 100% up to date. And then how does that apply in terms of the training and the follow-on processes for managers being aware of that? So then again, if they're not applied correctly, can cause a lot of inconsistencies. And that again, that's how that managers, they rely on assumptions then from what they've heard maybe from other managers, were they trained well enough? Again, it's those decisions which are then made, maybe just verbally with no record. The manager's gone, well, when you've asked them for that, chronology of information, the reality it's probably sparse and doesn't really have a lot of detail. And then again, I suppose on the other side, in terms of linking it back to pay and probably sort of, in terms of family-friendly policies, how's that being correctly done if things have not been recorded correctly? And I think it's helpful to probably understand that this is a process where it's not always about the policy. It's about the application of that and the process, which derives from training, it derives from communication, signposting, documentation that is supplementary to the handbook or your contracts, especially when it comes around decision making in the early stages of an onboarding process. I think even the term onboarding is quite a loose term. We in HR, we always use the word reasonableness. What is reasonable? And I suppose what is reasonable? It's a long drawn piece of string, really. I suppose when we're looking at it in terms of onboarding, for some businesses, it may assume it's a day, it's a week. In reality, best practice probably would suggest it's probably up to the end of probation. That is a long time for that individual, as I mentioned, to learn names, processes, signposting. So while there's an inherent need to get it right, there's an inherent need not to rush that beginning of that process and actually spread things out in terms of how we apply those policies throughout and fed to that employee. It gives that managers time to sort of be able to check in rather than miss things. And then again, while we're covering it in this webinar, that obviously will affect as we move into the changes with unfair dismissal, and as a lot of businesses now are reflecting upon their probationary periods. So just moving on to the next slide, and we're probably just going to do, as I mentioned, a bit of a quick recap on existing day one rights. I started off by talking about, I suppose, the implications and sort of the escalations of the importance of day one rights. I suppose good to talk about what they actually are as well, and this is it. So before we look at it, I thought it's useful to collate the current existing ones here. Again, you'll get this slide deck after, so I think this is a nice little checklist if you haven't got one about the things you should be looking at. Some of the, obviously, these day one rights aren't new, and it's easy to forget some of them actually in reality to what we do, because these sort of these go through the process. We expect these things now as employees to sort of do as we're onboarding people. Most employees now obviously start within the legal protections from day one. Many managers realise pay, leave, safety, fairness, as I mentioned, and speaking up against discrimination. As we obviously layered in these new rights here coming from April. So you've got your statutory sick pay, you've got paternity leave and parental leave. We've obviously got the existing ones, and I think it's not, it's to not lose sight of them. Written statement of particulars, so your employment contract should be with that individual from day one. The big part of that is obviously that came from the good work plan, ensuring that obviously contracts, handbooks, or if you sort of dovetail them, which is a good way of good practice, is to making sure you're covering certain elements of practical employment law. So from maternity training, all the sorts of things you'd expect, having those sets of sort of conditions, first of all, sets of ground rules running in terms of how you're going to base your signposting, so how your application of your processes for handling parental leave, handling flexible working requests. National minimum wage, I'm sure many businesses and individuals here we think we're covered, which is great, which is absolutely probably the case. I suppose when national minimum wage you need to look at, it's probably when you look at calculating leave and when it becomes irregular. Those are sort of potential pitfalls of maybe not understanding that and going about, well, we probably should reflect and look at that and reports and see how that's engaged. Paid and annual leave and breaks, again, these things are probably standard stuff we know. Protection from discrimination, again, it's that it's quite a broad term, but I think we look at that in the respect of, looking at how that employee is trained about discrimination from day one. So we know that it exists, that employees should feel safe and supported and protected from discrimination. But how is that actually communicated through to your employees? Do they do training? Does their manager support them? How is that actually practically delivered? Again, it's not just about policy. It's not writing in a handbook that you are protected or this is what we'll do. There needs to be a little bit more support around that. Again, as we mentioned, we've all started a new job. These are a lot of information. I suppose we just need, how do you practically ensure that? Is it 2 weeks in, they have the HR webinar, they have some training, whatever you layer that in, maybe with some of your other recent changes with the Workers Protection Act, things like that are really good to think about. Protection from unlawful deduction of wages. Again, well, many of us will know that obviously we can't just take. We have to have this prescription under that. Obviously, when the Employment Act started in 1996, that one, but obviously that extends now through to the ERA 2025. That obviously we have to have specific reasons around what we can take for those from wages, and obviously it has to be explained and agreed upon with that individual, unless it's a statutory right. So right to itemized pay slips. Again, many of you will be doing this automatically with your pay runs, with your bureaus, whatever you're doing or manually. Again, that's absolutely crystal clear in terms of the Act. Whistleblower protections, that exists already. Again, that's obviously we should be aware from April there is enhancements in terms of whistleblowing protection to include sexual harassment. So that now falls under a form of whistleblowing. You've got the health and safety protection. So that's obviously safety at work, and that extends again to individuals in terms of safeguarding, young workers and those different types of employees that you have within the business. So just obviously well aware of that. That depends on business to business and what depends in terms of your health and safety requirements. But again, it is a requirement to obviously offer that individual training and support where necessary. And then the flexible working right to request from day one. Not right to guarantee and just accept it, but the right to request is a part of it. So as I mentioned, we've obviously got SSP coming in, paternity leave being brought forward now, and our parental leave, again, obviously remove that qualifying period. These are all confirmed. There's no additional secondary legislation, code of practice, or anything like that. This is just being brought forward as is they are now. There's some changes which we'll get into, but in reality, they've just been brought forward. Move on to the next slide. So we're going to get into the actual day one rights, which are coming in. So get a little bit of detail. So with SSP, what's actually changing? Okay, so SSP pay from day one. So the waiting days have now been removed. Lower earning limits are removed. I suppose let's probably get to a bit of a more of a real scenario. So, SSP is probably going to affect where we feel absence increases across many businesses. Where that'll probably hit many employees is probably in the lower paid earners within your organization. SSP, obviously, as we know, isn't an incredible amount of money, but it probably will affect how employees think to a point. If they're on the lower end of the spectrum, it reduces that, I suppose. Well, I'm not getting anything today, so maybe I'm going to get something where I didn't. So we're probably going to see a shift in maybe that sphere. We're predicting probably increased absences, maybe if you're in the hospitality retail sector, where minimum wage is more of a common initial entry level position. And that's probably where we're going to find probably some significant increases in absences. I suppose when we look at probably in a practical world, how the risks could apply in terms of SSP as a day one right under the arching view of the FWA and the other legislation that's coming in is, you've got a new starter, text the manager, really sorry, woke up with a fever, don't think I can come in. Manager's instincts, as we all are, is probably well-meaning. Let's see how you feel tomorrow. Hope you get better soon. But from April, that casual wait and see has some risks because it's not just about supporting that employee. It becomes a payroll and a record-keeping decision risk. To explain, let's say the employee doesn't return for a week. So it's fine. So the manager gets a text. They may self-cert themselves off. They may get a fit note. The manager sits on that and goes, well, okay, gets back to busy as usual jobs. I'm sure, HR individuals, managers get on with business as usual. By the time the employee comes back in, the manager actually looks to process that information. Payroll's cut off. They send it to HR. I was going to have to wait till next month now. So it's going to get fixed in next month. No biggie, not probably perhaps a bit messy, but that's life. It's the way it goes sometimes. We're not looking here to cut hands off for just general working practices. But what we find is 12 months later, let's say you do get audited or you're looking to decide the decision making process, the risks isn't actually about if you've paid it correctly. You've done it right. Next month paid it correctly. It's whether you can evidence when and why it's happened. That's a big part of the FWA's remit. Is going, well, why? Why has there been a change here? Can you document that? So again, it goes to that level about, but normal practices in terms of just day-to-day stuff that happens in every business right now. I'm sure you have individuals off, our managers are busy. By the time you get it, maybe a week later. But there's there's an understanding about who keeps that email, where's it stored, so that if they need to obviously demonstrate that later, there's obviously an actual explanation to why that's the case. And why this matters, the government impact assessment estimates around 1.3 million low-paid earners were previously excluded from SSP due to earning thresholds. So obviously, as I mentioned, the removal of the threshold brings in lots more people for entitled to SSP. But obviously, within that, there is elements of individuals who maybe not being paid it correctly. And that may be due to a couple of factors. But it becomes immediate now with the practical risk, as I mentioned, around just that example about how things can sort of time delays, maybe looking at getting managers to be as soon as receipt things, or does it go to HR, how you process that information and keep those decisions about leave and pay is going to be crucial. So looking at a couple more practical risks, we've got payroll systems being coded for 4-day payments. Again, I probably spoke about this last time, getting that right. If it's in-house or you have a bureau external, making sure that they're up to date and making sure they're running that from day one and you've got confirmation. It's not your payrolls. You can't blame it on payroll after if they've not done it. It's it will be the punitive risk to you as an employer will be on you making those payments, not the bureau. As I mentioned, managers incorrectly delaying it, not having that information. I suppose absence reporting not aligned with payroll triggers. Again, that's a good one to look at. You may have sort of Bradford factor or maybe other sort of thematic leave indicators. Getting those up to date is going to be helpful in terms of how you manage employees. And again, maybe just not recording absences correctly. Again, it may be just wrong on the system. Again, those things happen. So, probably the key one is managers going, and a really good one is allowing people to swap sick leave for holidays. We've probably all had that request. Again, that's an even tricky one to now talk about because sometimes later down the line, that employee says, well, I never said that, I was sick. If it wasn't recorded and there's no evidence of that verbal confirmation, again, it leads to potential underpayments. Again, just having very clear policies about how you interact with leave and sick pays or any type of leave is important. And I suppose looking at the biggest friction here is employees often hear sick pay and assume it means normal pay, and managers often hear day one and they mean it's automatic and simple. Payroll hears new entitlement and assumes it affects long-term sickness. These are assumptions that people think of when they think of different sorts of terminology within HR and payroll. So in reality, the messiest cases, I think, as we're discussing here, are short-term, handled informally. And again, I suppose these are significant issues. This employee may return to work and it's not a long-term sickness case or capability issue, but in reality, these, as I mentioned, those £100 issues may be not quite correct. You didn't give me that holiday when I needed it. Those things are going to cost you more than that if you're audited. So this is why it's such a big part about having a good clear projection about how you handle sick pay. Move on to the next slide. So what does good look like? We touched upon a couple of things there. So as I mentioned, testing the logic, speaking to your payroll teams, if it's you, having a look at it, having a look at those sorts of processes I put it into. Look at short-term absences scenario, long-term sickness. Is your payroll built for it? Can you process it? Are you confident? Your bureau can confirm that's how it would look like, how it's calculated, and can you confirm that? Many bureaus out there, they're not HR individuals. We know that. So, just having that, they'll have a great knowledge, but you need to sort of make sure it works for your business. As we know, holiday pay in particular, and we're talking about SSP here, but holiday pay in particular, there is no set way, under law, to how to calculate holiday. There's entitlement, but calculations do vary. So the math around it depends on your business. Do you pay bank holidays or give them in lieu, etc.? There's contractual terms. There's lots of caveats. So getting it tested for yourself in your business I think will guarantee a bit of peace of mind. And then look at just your new starter process. We've talked about checklists before, but you'll obviously have checklists for your onboarding, for your payroll, if you have variable hours staff, 0-hour contracts, just probably looking about that ownership, about who owns between HR and payroll, about that that process, and making sure everything is completed, from a day one perspective, or in terms of making sure people are aware of the rights, but in terms of how they're handled. Looking at SSP here, manager execution is critical, as we talk about. If the day one, it must record it the same day. It's a pretty good example. Don't delay reporting if the return. I think clear rules on self-certification applies. There's no change under this legislation about that, but just getting people to self-certify, sending the S2 form, getting them to come back, how you do that. Can you guarantee that many people sign it back? Those return to work conversations, are they done? It's a bit tick box. Again, manager prompts in your systems, whatever you can do within yourself and people team in terms of your technology you have, or just as individuals and processes, look to sort of embed a very, very clear recording process. And then, for new starters and existing employees, clarity for employees, explaining it in plain English, when it starts, what it is and what it's not, not getting them confused between potential company sick pay or occupational sick pay. Putting together some FAQs is sometimes nice, a simple explanation to them. I'm sure some employees think it may be full pay. Again, just having that clarity of information available, I think, again, just cuts queries off your help desk or from your inbox, and just makes it a lot easier. A couple of smart controls you can put in. Go to the next slide. Worth saying here, most organizations, we don't want to be punitive in terms of, these controls. These things are here to just affect the system, and most employees aren't gaming the system, as we know. And the goal is not suspicion here. The goal is it's consistency, right? Isn't it? Good absence processes protects genuine sickness, reduces manager stress, big part of it, and prevents those small errors, as I mentioned, going into those very time-consuming disputes later on. I think some of the really key controls you can look at here, as I mentioned, absence trend monitoring, site level, where it may be needed to be looked at, and processes, if it gets to a certain one, it doesn't have to be super difficult. If there's a triggering system, it could be if they've got 5 days in 5 months, whatever it may be. I suppose what we're trying to do is that knee-jerk response. As I mentioned, the straw that broke the camel's back reactions. Managers should be following up things in a consistent way, not just when things now accumulate and become a big problem later down the line. As I think it's a case, trigger points, again, should be reviewed and tightened, as I mentioned, and those early well-being conversations rather than disciplinary processes, those help water down sort of frustrations, and generally probably find out a lot of issues can be settled and reasonable adjustments can be put in place very, very clearly at that point. And then, looking at, obviously having, when you speak to managers and working with them, defining what is genuine sickness absence and maybe patterns of concerning behavior. We've all probably had employees maybe after payday seem to go off on leave. There may be something around that. Do we need to actually bring a welfare check, have that well-being conversation? Again, all these things are protection for those potential claims down the line that you took early intervention rather than just disciplinary. And again, we're thinking wider, bigger picture, how this affects with unfair dismissals, and obviously, going further down the line this year, this is a really good tool of just sort of sharpening up those things. We're going to move on to paternal leave now. So this is this is what it is on the tin, really. We're going to removal of 1 year service requirement, which exists at the moment. Employees are eligible for unpaid parental leave from day one. I didn't actually say unpaid in my last webinar, so apologies. I just said parental leave. It's definitely not paid, it's unpaid. And I think why this matters operationally and what the changes are in practice, Doesn't change, a surge in leave requests, I imagine, but exposes long-standing weaknesses in how probably paternal leave is understood and communicated and administered. I think a lot of evidence shows that there's a low take-up on parental leave, and probably driven by poor awareness, manager misunderstanding, rather than the lack of need of it. We all might get the odd, I need an emergency child care day here, I need to do this, I need to do that. There may be things, I suppose, simmering under, which potentially could become long-term absences, and maybe the application of parental leave could be really good for. There was a government commissioned evidence shows that awareness around parental leave is patchy, it's inconsistent, particularly outside HR functions where HR individuals have a really good understanding of it, but we probably don't see the managers having a very, very clear understanding of it. There was a large-scale union research piece around that my manager, there was an example really where my manager didn't even know how parental leave worked, as in it was used as a barrier really. That's a really good, probably singular line from that research, which from Unison, which probably explained employees asking their managers, do you know what parental leave is? Okay, it's a good question. Do your managers know the answer? Again, this goes back to those day one rights. Having not a lot of clarity can cause a lot of problems. The take-up of unpaid parental leave remains low. Again, reinforcing that it's it's not a volume risk, but maybe it's just an awareness problem again. So if there's an awareness problem now in terms of the use of it, well then, because the risk now is amplified, again, that speed camera now is off the driveway rather than a year down the line. If an employee does sort of ask you from maybe the first week of employment that they need, the child is significantly poorly, they've got something going on, they need this leave, child care arrangements have changed, and the manager goes, "Whoa, there's a big significant. I don't understand this. Don't know what that is. Take some sick leave, take some absence." Again, we're sort of, we maybe, we will be infringing on that individual's rights. So the risks. Move on to the next slide. What's probably most likely to happen? Probably during onboarding. It's probably childcare arrangements. We find outside of most individuals, particularly during job stage interviews, again for the right reasons, don't disclose their probably preferred working arrangements. Maybe there is a change in childcare because half term comes up when they start. There could be certain things during that probation where there's a change in that employee's needs and they do need this type of leave. And again, where, as I mentioned, when managers are just least, they're not very confident, and as HR, you might have low visibility around that employee, especially during that the onboarding time. It may be HR's had their induction or their information has been sent over and you've handed to that manager, then it becomes very much on that manager to sort of support that employee through the next stages. So as what realistically we can expect, move on to the next slide. I don't think employee behavior is going to change. Again, it seems it's quite low in terms of the statistics. Again, I think there's a powerful, conversation to be had about its uses. But again, that applies in the businesses and how you wish to apply that across. I don't think, even if you advertise, I don't think many people are going to go, you'll see a surge in requests. It is an unpaid leave, remember. That's obviously going to apply a financial constraint. I think, again, as I mentioned, most requests likely boil down, and probably many of you can probably relate to this, is childcare, breakdown, school transitioning points, caring needs following family change. There's some evidence to say there's high likelihood requests from parents in more lower paid roles because of the need of flexibility, and employers with limited flexibility or informal support networks. So those who may not have the family setting that would be a typical family setting that require those responses. Probably just getting down to sort of manager behavior. And a really good example of probably what we're trying to discuss is, and as I mentioned, a colleague may start the job day 3 and say, I might need a couple of unpaid parental leave days next month. Childcare's changing. A confident manager and a well-informed one, as I would like to think, would say, okay, let's talk for the dates and cover this. And that then translates to HR. It's put on payroll. There's a decision. It's recorded. Decision making is clear. Very compliant process. I suppose an uncertain manager, maybe now, even probably more likely, would go, may say, and this is the type of language we want to avoid, go, you're a bit new for this, aren't you? You're going through your onboarding process. We've got training next week. There's probably some good intent behind it in terms of, in their mind, that is, but in reality, it's, there's a different risk profile now that's occurring rather than a year down the line. So day one rights are often less about bad faith here. It's more about managers' confidence or lack of it in that moment. So let's move on to the next slide. Yeah, and I think we can talk about some practical risk here. So again, as I mentioned, those incorrect refusals, leave being refused on probation, again, outdated assumptions, maybe sort of on a lack of awareness, and then I suppose delaying that approval, getting to HR. How is that approved in your business? It's a really good one of thinking. Is it managers approved? Is it HR approved? Do they need both? That might be outdated. It maybe needs to be rethought of how it's done. Is it email? Is it by your HCM system? Again, obviously, policy drift. We always find this anyway. Policy is still referencing 1-year thresholds. So obviously, that needs to be all up to date. Eligibility after 12 months, those type of wording you still need to eradicate. Where you may have a handbook and you may have policies which are separate just for maybe the way the business works, don't leave it in one. You're obviously going to have to do an exercise which could be quite significant to make sure wherever it mentions this, that it's obviously supported and removed. Offers letters, onboarding packs, anything you don't want contradicting information. Again, as I mentioned, that'll leak into HRS systems where you may have blockers on it. It may not allow for 12 months under service to have this type of leave. So in the drop down, it may not appear. Again, that will depend on your system and depends how you've set that up. But again, we don't want that being recorded incorrectly, given the risks we've talked about before. And then obviously probably more of a strategic workforce planning sort of situation is headcount absence based on eligibility assumptions, team unprepared for sort of short-term absences. I suppose where risk is applied is where we think, well, we can't guarantee that leave because we're short-staffed. We're not aware of this. We hired you for this position because we need them. There has to be a degree of decision making around that. And then what does good look like, right? So we've talked about the risks there, and I suppose, as I mentioned, obviously I'm feeding these through the conversation, but early visibility, as I mentioned, getting the parental leave explicitly referenced, as I mentioned, for all your documents, make sure your managers are aware of it, clear signal that family-related policies, they're not the day one, they're not for after probation, and then a client, as I mentioned, documentation, very similar to SSP here, policies, procedures, FAQs updated, removal of anything legacy systems, and I think a very clear explanation about what parental leave is, how it differs from maternity, paternity, and shared parental leave. It's a good one to always clarify. And I think any sort of hygiene, look at your systems and give a bit of a hygiene check again for any type of leave processes. You may have a big drop down list, as I mentioned, of different types of leave that may trigger different type of payments. Again, it's always good to sort of come and check that and have a look at it. And then afterwards, after April, I'd be monitoring this. Make sure you look at your reports. Is there an uptake? Is there not? Is there no change? Again, if where people are having leave and the reason is emergency child day and there's been 5 of them, and they've unpaid, was that the right type of recorded leave? Should it have been parental leave? Again, those type of things are important. Next slide, please. And again, as we said, manage confidence, get them trained, get them support, get them focused on what do I do if this comes up in a week, what comes up, what can I ask, what can't I ask, and a clear escalation if there's a complex situation. Get yourself, on the radar of your people team. Okay, we're going to move on to paternity leave. And I'm probably not a shock, but the UK is amongst the least generous in Europe for statutory paternity leave. I'm sure we're all aware of that. They're offering just 1 to 2 weeks at a low flat rate. By contrast, we've got some countries out there, Spain, 16 weeks full pay. France is now at 4 weeks. Come on, England, UK, you need to get sorted there. And the Nordic systems offer a well-paid and father-specific leave. Again, we understand that it's not as significant from that. But again, we are sort of the bottom end of the European league in the league for paternity leave, both of length and pay. And that obviously limits the ability for fathers in caregiving roles, especially reinforcing that gender equality at work. I think where this becomes, I suppose, an interesting model from the Employment Rights Bill is obviously the offer. This is intention to obviously allow that to, I suppose, bring that forward, provide that day one opportunity and reduce maybe potential guilt of fathers not having that if they started a new job, and then being penalised for when parenthood arrives. So I thought it makes it a little bit more fit for purpose, and considers that sort of stronger entitlement for better supported families and participation in work. So, but it's obviously, this is a good thing. I'm sure all of us agree. It's obviously still low behind many things, many other countries. Why I say that in a probably overly tongue-in-cheek way is maybe it's an opportunity to look at it, right? Maybe as a business, costs are up, we appreciate that, demands are high, but these type of things, many businesses now, I think over 80% of the UK now have a more of an enhanced maternity scheme. Maybe that if I'm sure many of you have applied paternity then if you have, but if you haven't, again, looking at maybe even just 2 extra weeks could be a really good start, especially if the salaries remuneration pitch isn't as strong this year for many of your employees because of maybe the business performance or whatever the environment you're in. Again, these are just other, intrinsic, things that you can apply to, to obviously building loyalty for your employees. So what's actually changing? Quite simple. Removal of 26-week service requirement, ability to combine this now with shared parental leave, which is the same thing brought forward. Why does it matter? I think again, there was a slow uptake on shared parental leave. I think that's why they've brought this forward effectively. Again, driven probably by manager uncertainty, inconsistent messaging. It's probably not a lack of interest, we don't think, but I mean, there was actually government evaluations that the usage of shared parental leave actually has not even changed since its installation 11 years ago. So probably this is an effort to then obviously provide a little bit more balance between who takes leave and when. So this is probably a little bit of sort of trying to cross that bridge really. So move on to practical risks. I mean, there's probably quite simply incorrect refusals, payroll errors that may come out of this, and I suppose how that would link then to potential issues of employee, would there be discrimination or detriment, right? That would arise from poor handling of these. I think many businesses would have a good handle on paternity anyway, but again, understanding that it's how you process that, and very much linked to the other elements of SSP and paternity leave, parental leave. Sorry, that having sort of clear, simple guidance for managers, payroll testing, making sure that the leave types are right, consistent messaging from all your documentation, your FAQs. So I think that's a kind of important part. Having the similar sort of practice across any of these day one rights is going to be crucial. Shall we move on to the next slide? And we'll just skip ahead. Okay, so there we go. So this is now what HR teams now should be doing, a bit of a practical focus. So we've talked about the beginning of the session, we looked at, I suppose, the impact, why day one rights are important. So from all the way from looking at sort of how the increased risk with the FWA, managers being a culpable part of it, and obviously in terms of how that will be processed. We've gone through the existing day one rights. You've got a bit of a checklist there. It's always good to enforce those. You have quite a few now. And then we've gone about looking at the new day one rights, plus a couple of practical reasons and how to sort of support that. So where we're going now in terms of HR teams, it's about now the useful bit comes what to do. So I'll be honest, most of the risk prediction doesn't come from rewriting your policies here, as I said. It comes from removing assumptions, making sure that problematic, real life, week one situations are supported by processes and systems that actually work without having need to be really heroic about it. So removing false comforts, removing surface thresholds that no longer apply, getting those out. Many organizations are probably relying on policies that look compliant but quietly assume service thresholds no longer apply or are worse, where contracts and handbooks and standalone policies don't fully align. Again, this is not, this is just the way we work. Documents sit there, we focus on them, we do rely on them as our sort of kind of foundational knowledge, but things move on with businesses. We create a new contract, we change a policy because of a situation, and then we end up with a collective documents sort of maybe misaligned. The matters here, because tribunals will always look, and we know, at consistency. So we'll find against employees where written documents contradict each other, where their processes then from those documents contradict each other. So the decision to do something with an employee, one manager said this and the other manager did that, therefore becomes a very inconsistent process. And employment lawyers repeatedly identify outdated and consistent policies as a common factor of losing cases. So if you take it back from the the root cause, processes being the issue, and then probably the documentation that followed on it, or no training or lack of clarity. Good practice here. Policies are explicit, simple, plain English that apply from day one, just as important. That's importantly, that's how it works. What you can't rely on, I suppose, implied waiting periods as well, which sort of are hidden in certain contracts where they were sort of put in so you didn't have to keep changing if things moved in law. Getting it clear, get it says day one, that sort of helps. Designed for week one, not month 6, is a big one. So obviously we know unfair dismissal, but it'll be a 6-month sort of parting from obviously January next year. Move on to the next slide. Is we've obviously got to design now from day one. So if a right only works smoothly once it's embedded, it's already a risk. Day one right stress test the organizations. Probably the weakest point, onboarding gaps, incomplete records. Managers deal with unfamiliar scenarios. Levels of quality of experience in managers across your business. This matters because early stages disputes now make, as I mentioned previously, a large proportion of employment claims. And again, this is, a big drive in terms of employment cases we've seen, especially under 2 years. A lot of ACAS data shows majority of claims originate from employee-led action, often following early handled issues rather than long-running disputes. So where we think potentially that long capability case is going to cost us more in time and effort, probably short-term issues. That individual worked for you one day, went off sick, and now has caused you more problems in time and resource than actually maybe that long-standing employee issue. These are really big things about getting prepared. Good practice here, look at your systems. I mentioned processes that work, that don't go off script. So having clear routes of what happens when a day one right is applied. So let's say flexible working request, where does that go to? When is it responded to? Who handles that process? And who writes that response back? Having very clear delineations in authority and responsibility. So that isn't just sat in a manager's inbox for 3 weeks, and by the time it gets to maybe escalation, less chance of going off script. We'll move to the next slide. Treating payroll as a risk control, not an admin function. I think that's why I look at this as, the SSP one in particular. Moving to a day one right, and enforcement now, as I mentioned, the FDA becomes a lot more retrospective and punitive. Payroll errors are no longer low impact mistakes that can be quite fixed. These are enforceable liabilities. This is a significant because statutory payments, as I mentioned previously, now can be recovered up to 6 years, with 2 years for the holiday claims. With the financial penalties on top, there's going to be the ability for employers, as I mentioned, to bring claims against the business and the FWA to charge you for the pleasure of that. This shifts that, as I mentioned, that payroll accuracy and operational hygiene to financial risk management. HR plays a significant part in the process, so it's a really important part of it, and that's why it matters for you as people professionals. Good practices, again, as we talked about, working out the payroll logic. Payroll should be automatic. It's numbers, it does things, it should work, but we all know it's how we apply it for our business. From day one, it shouldn't be about judgments that it does work or assumptions that it could and it will do. Getting that or just manual intervention, fixing things as you go. There's got to be a very clear process in terms of how your payroll is going to work. As I mentioned previously, stress testing, looking at it, getting confidence that if you do it or your bureau do it, things work out in the way that your contract and your handbook and your processes suggest it will do. And if it is, those things explain things. Payrolls are, pay slips can always be a quite hard thing for employees to understand. They think that maybe a deduction is a pay, with a minus in front of it. There can be a lot of assumptions there. So again, good practice, good call to actually get those pay slips looking clean and clear, and maybe some FAQ document with it to explain what it is. It's a really good opportunity to do that and bolster understanding around pay. Moving on to the next slide. I've talked about this. I've probably hit on managers quite a lot in this session. I'm not to blame all managers. Being a manager myself, I think we've got a good understanding of businesses and individuals. But assume managers will act before HR is involved. That's my mantra, and I always think, managers deal with the employee every day. HR don't. So most failures always don't start with HR. Probably there's a manager trying to be reasonable, flexible, pragmatic in the moment. Unfortunately, tribunal decisions that repeatedly show informed decisions are among the hardest to defend, and they are because they show inconsistency. because these are really documented in a clear manner and why the decision was made, more or less usually the most important part, they're remembered differently later. So, good practice would be that individual, you give an allowance on that day one or that flexible working right, but you didn't write it down, and then somehow manager changes, then it needs to be, that individual has to come back into 4 days, at the office rather than 5 at home, 4 at home. There's things where there's probably a good element about that. It was true and necessary at the time, but if it's not documented, it's going to be really hard to defend the reasons why that was done. The employee is going to always remember that differently because they feel hurt or infringed upon because they feel it was something was agreed to and taken away from them. I think it matters because, again, that poor and missing documentation is often, as I mentioned, is a top reason for employees to lose tribunal, just not having it. If someone claimant brings something to you as a claim and you have nothing to defend it, well, then it's going to be harder to prepare a defence upon that. Good practice is getting those guardrails in place. We all know that managers are the gatekeepers here, knowing where discretion ends and where to pause and reflect and escalate. I think that's a great confidence in the manager. They don't have to know everything. Managers, again, we talk about them having the knowledge in certain areas, which you still do, and having confidence, but knowing when to pause is probably a bigger skill. And going, actually, I probably just need to seek some advice on this. Moving on to the next slide. Can you evidence it? So from we do the right thing to can we prove it later is probably my sort of assumption of this. Again, I've probably the undergoing narrative through this conversation and on day one rights, Unemployment Rights Act is record keeping is no longer admin. It's not an administrative burden, it's an afterthought. It has to be a frontline risk control. This goes from FWA or tribunals, decision making and record keeping, having good chronologies about why an employee was off, the well-being, return to work meeting, and all those sorts of things, and what did an employee do to support that employee. These will be powerful tools in evidencing decisions that were made years, months ago. So therefore, when it's necessary to review those, either maybe even just before it gets to a formal litigated circumstance of a grievance appeal, there's a clear story and a narrative about that situation, rather than missing gaps that people and investigation managers have to sort of fill in or therefore cannot answer. So with the Fair Work Agency in particular, they will have those powers, as I mentioned, to find for getting decisions wrong, but also poor record or missing records. That's evidence to comply for compliance. So having the decisions about why pay was changed. At the time, tribunals, as I mentioned, years will come. Now we're seeing cases coming in for preliminary hearings, not even a full trial, to 2028. Memories are going to fade. Employees' memories, managers' memories, people leave the business. Again, having those documents, which obviously record conversations, explain things about where decisions were made, if that individual, why that flexible working request was denied, for example, really help build upon that protection there. And I think that's for UK employment lawyers, we probably know inadequate documentation is probably one of the repeated issues that we find, is just not having enough detail really, and then we rely on obviously evidential witness statements, which again can be brought into tribunal later on, probably really hacked apart. So really, just probably keeping it good practice is defensibility, keeping clear, proportionate records, decisions, why decision was taken, what factors were considered, and whether alternatives were explored. If not, on why not. That's an also good part. Why didn't you do something? When a narrative is missing, lawful decisions become vulnerable, and that's when you need a solid backbone. Keep your documents together. I think it's a really good one. So before we end, probably just if you take anything away from today, is probably take these 3 questions. For anything from the day one rights you can apply is think about the process. Can we do it correctly? Think about the behavior. Will managers do it consistently? And evidence it. Can you prove it later? And I apologize, I've run well over time here. I'm going to pass you back to Hannah for just the end of the webinar.
Thank you very much, Patrick. We have ran over slightly. Now, there was a lot to cover. I'm sure you can all understand that. And Patrick has made some really, really interesting points. I don't think we will do the Q&A justice if we try and rush through it now. So what we will do is we will take your questions and we will create a Q&A document that we can then share with you, rather than trying to rush through them, because there's been some really brilliant questions that have come through and we do want to make sure that we do answer them for you. So I will just quickly wrap up the session for this morning. So as I mentioned, this was the first session in our ERA series. So we do have another 2 sessions that are taking place, one in March and one in April. The March webinar is looking at SSP and absence management, and our April webinar is an ultimate compliance review. So I highly recommend that you sign up for those 2 sessions as well. If you click on the link here on the slide, you'll be able to sign up for the next 2 sessions. Like I say, there's one in March and there's one in April. And also, we wanted to make you aware of our Employment Rights Act consultancy service. So there's some information here on what the service covers. And again, if you click the link, you can find out more. When I end the webinar, a short survey will also come up and you can fill your details in here, and then we can arrange for one of our colleagues to contact you about this service if you would like to get a little bit more information on this. And our Knowledge Centre, as always, that's another place that you can go to. You can get to it from our website. Here we will promote the webinars. We've got our compliance kits that do also cover ERA. There's blogs on ERA and also other topics as well. So go and have a look there if you haven't done so already. And here's some information also on our HR support that you can take a look at. And finally, we would love to get your feedback in order for us to help shape future sessions. So you can click this link here to share your feedback, or you can also share any feedback that you've got in the Q&A panel within GoToWebinar as well. So I would like to thank you all for attending the session this morning. There's been so much useful information covered. Thanks to everybody that asked a question. We will be following up on those. I'll be sending out an email this afternoon with a copy of the slides and also the recording, so you will have that to refer back to. But thank you to everyone for joining. It's been a fantastic session, and we will hopefully see you on the next 2 ERA sessions in March and April as well. Thank you, Patrick, for a brilliant presentation.
Thank you. Thank you, everyone.
It was fantastic. And we will close the webinar now. Thanks everyone for joining, and enjoy the rest of your day.